It's the night of July 21st, 2002. Paramedics are called to Miss Jennifer Masson, a chronic asthmatic who has collapsed on her friend's front lawn after reporting a worsening wheeze. Mr. Clinton Peters, a critical care paramedic, and another crew arrive on scene, who begin ventilations and administer a dose of intravenous salbutamol as Miss Masson is suffering a severe asthma attack. A marked improvement in her vital signs occurs before rapid deterioration 20 minutes later when Mr. Peters administers IV adrenaline. Should be noted that Miss Masson usually carried an EpiPen as her asthma is responsive to adrenaline, however did not have it on her person this night, and the paramedics were unaware of this information. Following this event, Miss Masson suffered hypoxic brain injury and permanent disability for 16 years after, until her death.
In standard practice, the use of clinical practice manuals and guidelines are utilised to assist paramedics with clinical decision-making and therefore need to be specific. However, they alone are not simply relied upon. Firstly, a duty of care did exist between Mr. Peters and Miss Mason on the night of July 21st, 2002. Secondly, Mr. Peters did not fall below the standard of care as attained to by trial judge Henry J, and therefore a negligence claim will fail. As seen in the trial case, the CPM was critically analysed for a significant amount of time to determine if a backslash meant and or, and whether all aspects of the diamond needed to be met to move through the flowchart or only one. So if such analysis is necessary once an issue is brought to the court of law, is it not reasonable to assume that the CPM is vague and nowhere near the specificity required? Issues involving the accuracy of these guidelines have surfaced before in the New South Wales Ambulance v Worley 2006 case, where the medical bodies believed the guidelines should apply in extremis. However, there is no guidance given by QAS to say when it should be implemented. Essentially, this issue of specificity is what the court case rests upon, and as to whether deviation from it was accepted and justified.
Specifically within the trial case, Mr. Hucker, a critical care paramedic, opined that the QAS guidelines are designed to be flexible and used by well-educated paramedics practicing sound medical judgment, which Henry J agreed. The decision was made that Mr. Peters' actions did not breach the standard of care according to the Civil Liability Act 2003, as he acted in accordance with a practice accepted as reasonable by a credible body of medical professionals. However, a divergence from this perspective arose in the appeal case. The decision was made that the action of Mr. Peters fell below the standard of care, primarily because he deviated from the guidelines of the CPG. Despite the Bolam test affirming that his actions were supported by a credible body of medical professionals, the appeal judge, McMurdo J.A., went on to deny that paramedics had the medical competency to judge these competing views and apply them to practice. Murdo J.A. came to the decision that because Mr. Peters deviated from the guidelines, he did not exercise a reasonable standard of care and consequently was found negligent.
Mr. Peters was found negligent by McMurdo J.A. However, an issue with her reasoning and decision-making is evident as seen in her statement. There is no material evidence to prove if adrenaline would have been more effective. Thus, the real argument here is that Mr. Peters' clinical judgment regarding Miss Mason's tachycardia and hypertension was justified. McMurdo J.A.'s opinion differs significantly to Henry J. He agreed that Mr. Peters' decision was justified due to the associated risks of adrenaline, along with the equivalency of both drugs in the pathophysiological effects of bronchodilation. This decision was based on the substantial credible opinion from a professional body. The Blefo test, a modification of the Bolam test, determines that a body of medical opinion can only be accepted if it stands up to logical analysis. In this case, Mr. Peters' clinical judgment was logical due to the increased risk to Miss Mason's already dire condition, and consequently does not equate to a breach of duty of care, as defined in the case of Rogers v. Whitaker 1992.
The severity of the potential adverse effects of adrenaline can be seen in the New South Wales v Worley case. The paramedics administered adrenaline intravenously, however the side effects resulted in Mr. Worley suffering from intracranial hemorrhage and hemiplegia. Despite the supporting evidence of the professional medical body of opinion, McMurdo J.A. still ascertained that the choice of Mr. Peters to administer salbutamol over adrenaline was not supported by evidence. She claimed that Mr. Peters' preference for salbutamol was inconsistent with the reasonable care and skill of an ambulance officer, and therefore Mr. Peters was negligent. However, Mr. Peters did not breach the standard of care as he followed the CPM guidelines by considering adrenaline and assessing the risk versus benefits of adrenaline according to her presentation. The term consider is defined as the ambulance officer has to make a judgment regarding application of the following treatment modalities based on potential benefits and adverse effects. Therefore, Mr. Peters demonstrated clinical judgment in his decision and followed the CPM guidelines, thereby acting within the standard of care of a reasonable paramedic. Furthermore, there is no material evidence to show that the admission of adrenaline as initial treatment was causation of hypoxic injury that Miss Mason suffered.
Statement of claim pleaded negligence against the defendant on the basis that if adrenaline had been administered on the 21st of July 2002, the asthma attack would have ceased and on the balance of probabilities would have resulted in the plaintiff avoiding hypoxic brain injury. As to addressing the issue of causation, what needs to be established on the balance of probabilities was that early administration of adrenaline would have ceased the asthma attack, restoring adequate cerebral perfusion, and that no hypoxic brain injury had already occurred prior to the arrival of the defendant. Former, as established by Belitho v. City and Hackney Health Authority 1997, the factual inquiry is, by definition, in the realms of hypothesis. The question then lies on what would have happened if adrenaline had been administered. Using the but-for test to establish causation, asks if but for Mr. Peters' emission of adrenaline, Miss Mason would not have experienced hypoxic brain injury. Based on the balance of probabilities of Miss Mason's previous excessive adrenaline use when experiencing a severe asthma attack, the answer may be yes. Irrespective of this, professional medical opinion could not and would not be able to establish the efficacy of adrenaline on Miss Mason in this situation, especially with a 6-minute time frame of inadequate ventilation. Only the possibility that it may have prevented her injury, as dictated in King v. Western Sydney Local Health Authority. Maynard v. Western Midlands Regional Health Authority asserts that negligence is not established by preferring one respectable body of professional opinion over another, therefore asserting that the approach to determining professional negligence as depicted in the Bolam test is irrelevant. Following the example of Belitho v. City and Hackney Health Authority, it can be asserted that what would have happened is not determinative of the issue of causation, therefore supporting that a break in causation is established and that an action for negligence is failed.
To conclude, we agree with Judge Henry J's decision that the negligence plea against the State of Queensland has failed.